Well, before last night's major leak from the U.S. Supreme Court on the Mississippi abortion case, it was the 9-0 ruling by the court on a viewpoint discrimination case out of Boston that was actually making all the headlines. The court ruled that the city of Boston violated the Constitution by censoring a private flag in a public forum open to all applicants, merely because the applicant referred to it as, yeah, you guessed it, a Christian flag. Every other flag was accepted and flown except one, the Christian flag. Joining me now to talk about the significance of this case is Liberty Counsel founder and chairman Matt Staver, who argued on behalf of the Boston resident and his Christian civic organization, Camp Constitution. Matt, welcome back to Washington Watch, and congratulations, by the way.
Thank you, Tony. Good to be here.
Well, Matt, how many cases is this that you've had before the Supreme Court?
Well, we've had about 25 cases or more before the Supreme Court. I've personally argued 3 of those cases, but you never get a case when it's like this, where it's 9-0. They're very, very rare, especially on a religious free speech case or any kind of religious liberty case. So this 9-0 decision, I thought we would get one after the oral argument. I thought it went very well. I didn't anticipate Justice Breyer, however, would actually write the opinion. And so miracles do happen. He actually wrote this opinion and all 9 justices signed on to it.
Now, am I mistaken, but did the Biden administration actually back your client as well? Were they on the same side with you?
Yeah, it's amazing. The Biden administration did. The actually Solicitor General, Assistant Solicitor General argued in our case here. They argued here because they knew that the case could go sideways if they didn't get involved, because they deal with parks as well. And they have different kinds of celebrations where you have events that are open to the public and events that are done solely for example, the government, like, for example, the lighting of the Christmas tree. That is a government-sponsored event, but at the same time, you have public-sponsored opportunities there, and the same thing in the national parks. So they have both public and private, and they wanted to make sure that that intersection between government speech and private speech is maintained, something that the lower courts got terribly wrong.
So Matt, how significant of a precedent does this set?
It sets a big precedent because it's, as you clearly explained, it's not just about the flag. In this case, the flag itself, the Christian flag that we know of, the white flag with the blue square and the red cross, that's the Christian flag. And that was part of the celebration for Constitution Week. The flag itself was not the problem, Boston officials said. You could fly that flag, just don't call it Christian in the application. So it was the viewpoint of that flag. If you secularize the flag, even if they said you called it Camp Constitution flag, we would allow it. But if you deem it to be Christian, it's not allowed, even though the symbol stays the same. So it really is much broader than flying a flag in Boston or on any flagpole. It's about excluding Christian viewpoints from a public forum, whether it's in Boston or someplace else, whether it's after school for a Bible club, whether it's use of a common community room or a band shell of a public park.
I mean, this case was so
viewpoints was unconstitutional.
Well, it was so blatant. I mean, I think there was like 268 applications that had all been approved, every single one of them. Only one was denied, and it was your client?
Yeah, for 12 years, they had no denials, no review of the content until we came to this one, and they said no. And the only reason they did is because of the one word, the word Christian, in the application. So it was very blatant. They did not hide that fact, interestingly, but they defended it and said, well, you know, even though we say it's a public forum, and even though our policy says it's open to all applicants, and that's how we've practiced it for 12 years, we've never denied an application. We've had pro-communist and anti-communist flags back to back by private groups. We've had all kinds of diverse issues. We're not going to allow you Christian viewpoint because this is now government speech. So the implications of this is in a public forum that's generally open, like, for example, school facilities after school for churches to rent or Bible clubs or whatever it may be. When those are open to the general public and secular groups can use it, then when the Christian group wants to use it from a Christian perspective, speak about or meet about from a Christian perspective, the government, as in this case, shuts the door and says, no, you're not welcome because we can censor what we want to. And they're unashamed about censoring Christian viewpoints and religious freedom. because they say it's government speech. We can do what we want to. That was the big case that was before the Supreme Court. And that's the implication. And that's what attracted the Solicitor General of the United States' attention.
Well, again, Matt, I want to congratulate you and as well as thank you for being out there fighting for religious freedom. And looking through some of the information coming out of that case, it sounds like the opinion may have been stronger if one of the conservatives had written it, because Clarence Thomas and Samuel Alito didn't agree with part of the reasoning of the majority, but they agreed with the outcome. Matt, always great to be with you. Thanks so much for joining us. And again, thanks for the great work you do.
Thank you, Tony. Always a pleasure to be with you.
All right, Matt.